Okay, good afternoon. So for today's discussion, we're going to continue with leave for victims of violence against women and their children under Republic Act 9262, or it is commonly known as policy, no? Okay, but before that, let me summarize last meeting's discussion or topic. So last meeting, we discussed already some of the benefits provided by the labor standards, no? Uh, those are the overtime pay, wherein an additional 30% will be given for those who work in excess of 8 hours, or those special days, like holidays or rest days. And then we also learned about the night shift differential, wherein for those employees who works from 10 p.m. until 6 a.m. in the morning, an additional 10% will be paid, no, in every hours of work between 10 p.m. to 6 a.m. Okay, and then we also talk about service charges, and then the SIL, or the service incentive leave, a 5-day leave given to employees who already rendered at least 1 year or 12 months in the company, and then these 5 days, if unused, will be convertible to cash. Okay, and then another one is the maternity leave, given to all female employees, regardless of the status, no, whether she is married or not. Uh, the employee is entitled to avail a 105 days leave for when the employee gives birth. Okay, another one is the paternity leave, wherein the husband employee is given certain days, no, which is 7 calendar days if his wife gives birth. Okay, and then of course for a maximum of 4 childbirth. Okay, then the last benefit that we discussed last meeting was about the parental leave for solo parents, um, wherein the solo parent employee will be given 7 working days per year. Okay, although all those benefits has or have conditions to follow or to be complied with. So as a reminder also, for those benefits under special laws or Republic Acts, I would again encourage you as a students to read the implementing rules and regulations, or the IRR, so that you will know more about those benefits, no? So for this one, I only discussed those important things for you to know. But again, as an HR professional later on, or practitioner later on, I would advise for you to really read, no, the implementing rules and regulations. Okay, so that was that was our discussion last meeting, no? Okay, so now let's continue with the leave for victims of violence against women and their children under Republic Act 9262, so known as the VAUSI law. So this law is about violence against women and their children, as used in RA 9262, or the Anti-Violence Against Women and Their Children Act of 2004. Again, this is a special law. Then it refers to any act or a series of acts committed by any person against a woman who is his wife, former wife, or against a woman with whom the person has or had a sexual or dating relationship, or against her child, whether legitimate or illegitimate, meaning to say, even outside marriage, no? So that's illegitimate. So within or without the family abode, which will result in or is likely to result in physical, sexual, psychological harm, or suffering or economic abuse, including threats of such acts, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. Okay, so if you've heard uh, women who is being uh, like being assaulted, no, by her husband or even a common partner, for example, but the condition there is they have a sexual relationship. Okay. Well, anyway, this is very, I mean, the terms given are very legal, no? But again, for the sake of, uh, for the sake, I mean, just to really, or to give you a basic idea on this particular benefit, this is the basis, no, on the employees wherein they will be given certain number of days in a year to 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 cater this kind of circumstance. Okay. Now, for the coverage and purpose, private sector women employees who are victims as defined in RA 9262 shall be entitled to the paid leave benefit. Okay? So, in other words, only those employed in a private sector, women employees, are entitled to this particular benefits. So, the leave benefit shall cover the days that the women employee has to attend to medical and legal concerns. For example, with those circumstances as defined in the previous slide, so if the woman is a victim and then the woman wanted to file a legal action against her husband or her common law husband or partner outside marriage, then the woman employee can use this paid leave benefits, no? So the employee can still be paid in availing this particular benefit. Okay? So medical, of course, if the woman employee wanted to visit the doctor. Of course, for this particular law, it is recommended that the women employee will visit or will visit a government or public physician, no? A competent public physician. Okay, and then the qualified victim employee shall be entitled to a leave up to 10 days with full pay. So 10 days is actually 10 working days, no? Not calendar. So 10 working days. So if the employee regularly reports for work from Monday to Saturday, so with that, the employee can avail, no? Anytime. But however, for the government, they don't have work on Saturday. So most probably Monday to Friday. So if the employee need to uh, do some legal errand, for example, I mean legal matter, no? The employee need to attend to, like, she's going to file a case, then the employee could leave any day for between Monday to Friday. Okay, and it is paid, no? So again, that's a maximum of 10 days with full pay. So for the requirement for the employee to be entitled, the victim present to her employer a certification from the barangay chairman or barangay councilor or prosecutor or the clerk of court, as the case may be, that an action relative to the matter is pending. So this is actually one of the requirements. This is a proof wherein the women employee is going to file a case to her husband or partner. Okay, so only a certification from the barangay chairman or councilor or prosecutor, whatever is applicable. And the usage of the benefit will be the option of the women employee. So if she wanted to avail this particular benefit, no? But of course, there are some women employee who undergone this kind of situation, but they opted not to file a case. But again, if they wanted to use, then they can avail this benefit. So if unavailed or unused, this is not convertible to cash and of course not cumulative. Okay, so that's the VAUSI law for another benefit for a women employee. Then the next one is a special leave for women under Republic Act 9710. Again, this is a special law and I want you to read the detailed IRR for this particular law. No? So any female employee, regardless of age and civil status, shall be entitled to a special leave benefit. Okay, so whether you're single or married, uh, you're you are entitled for this particular benefit. Okay, so the female employee will be given 2 months or total of 60 days with full pay based on her gross monthly compensation. But again, this 2 months is maximum, no? It doesn't mean that the employee within a year must maximize the 2 months or 60 days, but it's actually depend on the doctor's recommendation, the OB-GYN, on after the surgery, how many days the employee will go on leave, okay? So it shall be granted to the qualified employee after she has undergone surgery without prejudice to an employer, allowing an employee to receive her pay before or during the surgery. So in other words, it depends on the company policy, no? But if the employee allows uh, the benefit to be given, whether before the surgery or after, so it would depend, no, on the company policy or practice. And again, it is not convertible to cash and non-cumulative if not availed. So what are those surgeries that are covered in this particular benefit? So uh, all those surgeries related to gynecological disorders. So what does it mean? This refers to disorders that would require surgical procedures such as, but not limited to, dilatation and curettage, or we call it DNC, no? Commonly called it DNC. Or those women who have, like, for example, miscarriage, for example, or cannot give birth, and then after that, so the doctor need to dilate the reproductive organ of the women. So in other words, yeah, it's the DNC. So it's very medical. So and those involving female reproductive organs such as the vagina, cervix, uterus, fallopian tubes, ovaries, breast, adnexa, and pelvic floor, as certified by a competent physician. So it shall also include hysterectomy, ovarectomy, and mastectomy. So again, these are very medical in nature. So like for example, mastectomy, it's actually an operation of the breast, no, female breast. Now normally, if it is just a simple surgery, it only probably lasts, I mean, the doctor would recommend for like 15 days leave. So again, whatever the recommendation or the days given to you or to the female employee by the doctor, then the paid leaves would depend on that, no? So again, it is not necessary that the 60 days or the 2 months will be maximized. It would actually depend on the doctor's recommendation on how many days the employee should need to rest, okay? And of course, it depends on the kind of surgery. If it's minor or major, then again, of course, there will be a medical certificate stating the number of days that the employee needs to go on leave. Okay? Then that 60 days is within the 1 year period, no? Or uh, the whole year. So, for example, if the employee has two minor surgeries within the year, okay? Like for example, mastectomy, and then later on, she also undergone hysterectomy. So as long as it doesn't exceed 60 days, then the employee can avail the this special leave, no, granted to female employees. Okay, but if of course if the number of days given exceeds the 60 days limit, then those excess days will not be paid anymore, no. However, for this one, this benefit is being paid or will be paid by the employer. Now, we also have another benefit which will be discussed later on the later slides, no, on SSS. The employee can actually uh, can still file a sickness leave for, sickness claim for 2SS on this particular surgery, no? So you would be, you would say that it is a double compensation, okay? So yes, it is a double compensation, but it doesn't violate the law because this special leave is being paid by the employer, while the sickness leave filed uh, through the SSS will also be, will also, I mean, the payer for that benefit will be SSS. So it's a two different agencies or entities. Okay, so again, you can file two benefits for this through your employer and through SSS. Okay, and of course, for the qualifications or the conditions for the employee to be entitled, she has rendered at least 6 months continuous aggregate employment service for the last 12 months prior to surgery. Okay, so 6 months continuous employment for the last 12 months before the surgery. And then she has filed an application for special leave with her employer within a reasonable period of time from the expected date of surgery. So with that, the employee should notify the employer, by filing a leave form for this part for the particular uh, surgery. And of course, very important, she has undergone surgery due to gynecological disorders as certified by a competent physician. Okay, so with your application for leave, you need to attach the medical certificate, stated the number of days as recommended by your OB/GYN, or your doctor. So it's a requirement. It's a must that you submit a medical certificate. Then for the SS application, a the another requirement that must be submitted will be the sur in the record of the surgery, operational record, no? So you need to attach that also together with the medical certificate. Okay, so that's the special leave for women. And then another benefit is the 13th month pay under the PD 851 or the presidential decree, no? So this is a law during the time of President Marcos. That is why it's called PD. So presidential decree 851. So all employers are required to pay their rank and file employees 13th month pay. So regardless of the nature of their employment and irrespective of the methods by which their wages are paid, provided they work for at least 1 month during a calendar year. So that's the requirement. So again, it doesn't matter if the employee is regular, probationary, casual, as long as the employee has rendered for at least 1 month during the calendar year. So that means from January 1 to December 31 of that particular year. And it should be given to the employees not later than December 24 of every year. Okay, so that is why you notice for those relatives or yours that are already working, they receive bonuses, no? Christmas bonuses. That's actually their 13th month pay before December 24. For the minimum amount, the 13th month pay shall not be less than 1/12 or 1/12 of the total basic salary earned by an employee in a calendar year. So in other words, it is equivalent to the employee's 1 month salary, assuming that the employee has no absences, no, or present on all working days during the calendar year. So it does not include allowance and monetary benefits, which are not considered as part of the regular or basic salary. Okay, so when you say basic salary, that is actually the monthly salary of the employee, Okay, so for example, if the employee is given 13,500 basic pay for them per month, then the employee will be able to receive the 13,500 on December, which is the employee's 13th month pay. again, assuming that the employee has no absences or no leaves, no, for that particular calendar year. So the formula to get the 13th month pay is total basic salary earned during the year divided by 12 months, and that will be the proportionate 13th month pay. So why proportionate? Again, it depends on the actual day's work, no, of the employee for that particular calendar year. So let me show you an example. So this one, this is actually based on the handbook, no, 2020 edition. So here we have from January 1, 2018 to November 2018, the employee's daily rate is 537. However, on November 22, 2018 to December 31, the employee's 6-day work week of an equivalent monthly basic salary is 12,466.33 and 13,290.75. So since there's an increase, no, from 502 per day, it on November 22, it's now 537 pesos. Okay, so with the basic pay from 12,466.33 from January to November 21, after that it's now 13,290.75. Okay, so based on the data, so from January to December, assuming on January and February there's no absence, so the employee receives the exact basic pay of 12,466. Now on March, the employee has 1 day leave with pay, still complete 12,466.33 because it's a leave with pay. However, on April, no absence, and then May, 5 days leave without pay. So in other words, the employee went on absent, no, without pay. So instead of 12,466.33, the employee only received for that particular month a basic salary or pay of 9,956.33 because of the employee's 5 days absence or leave without pay. And then on June, there's also 2 days absent. 2 days leave with pay. So it's with pay. So again, the employee received the total basic salary. And July, no absence. August, 2 days leave with pay. September, no absence. However, on October and November, probably the employee was absent for 2 months, so on leave without pay. So the employee will not receive any salary, no, because it is without pay. Of course, this one should be authorized, no? So the employee really has permission. The absence is authorized by the employer. And on December, no absence. Total of 13,290.75 because of the increase of the daily pay of February 37. So it's bigger, no, compared to the months from January to September. Okay, so a summary, the total basic salary earned for the year is 122,977.72. Okay, we divided by, of course, 12 months. So the 13th month pay of the employee for that particular calendar year will now be 10,248.14 as the proportionate 13th month pay. Okay, so it will depend on the actual work of the employee of that particular calendar year. So that's how you compute the prorated 13th month pay. Now, for the time of payment, it shall be paid not later than December 24 of every year. However, an employer may give to his or her employees 1/2 of the 13th month pay before the opening of the regular school year, and of course, the remaining half on or before December 24 of every year. So, again, it would depend on the company practice. So, regular school year, especially now, or those schools that they have trimesters, but normally this is given on the month of June, no? So that's the commonly given during the half month pay, okay, and December 24, of course. Now, of course, there are employers who are exempted to pay their employees this 13th month pay, and they are the following. So the government and any of its political subdivision, including government-owned and controlled corporations, except those corporations operating essentially as private subsidiaries of the government. So as I said, the labor code is actually for private employees, no? So, but for the government employees, they have different. They are, I mean, they have different law who governs their employment, and they are under the civil service law. And another employer who are already paying their employees 13-month pay or more in a calendar year or its equivalent. So in other words, they already have an existing benefit uh, that pays the 13-month pay of their employees, and then persons in the personal service of another in relation to such workers. Okay, like for example, those actresses, no, wherein they have their personal assistants or for short PA, so they are not obliged to pay their employees 13-month pay. And of course, the last one, employers or of those who are paid on purely commission. So on a commission basis, so their wages or I mean their salaries would depend on their commission, so they are not required to pay their employees the 13-month pay. Now, for those resigned or separated employee, they are still entitled, no, to receive this monetary benefit in proportion to the length of time he or she has worked during the year. So reckon from the time he or she has started working during the calendar year up to the time of his or her resignation or termination from service. So in other words, even the employee is terminated due to unsatisfactory performance. So like for example, a probationary employee wherein the employee will be given 6 months probation. Now, assuming the employee failed the standards of the company, and then that employee will be terminated, no? So the employee can, upon the effectivity of her termination, of course, it must be, or the employer should have a standard system, no, wherein before separation, the employee needs to file a clearance, okay, for the employee to be cleared, no, on that particular company. So after filing the clearance, then part of the employee's last pay will be the employee's 13th month pay, the prorated. So if the employee only worked for 5 or 6 months on that particular calendar year, so the employee can only receive the proportionate or the 5 or 6 months equivalent work for that particular period. Okay, so here, this is another example. So if the employee only works from January to September, his proportionate 13th month pay should be equal to 1/12 of his total basic salary earned during that period. Okay, so for example, if the employee receive 12,000 per month as the basic pay, and then the employee work for 10 months, for example, or 9 months. So the employee, assuming the employee are present on those days, no, working days, then with that, the employee would 13-month pay will be, I think, 9,000. So you just divide. So if 10,000 times 12, that's 120. So you divide it by 12. And since it's only until September, so it's only 9,000. Okay, so just do the math, but that's how you compute, no? Now, what about for those employees who on maternity leave, wherein there are 105 days, no, or more? So how many months is 105 days? So 90 for 3 months. So more than 3 months, no? So the salary differential shall be included as part of the basic salary for purposes of computation of the 13th-month pay. So for this, I will not discuss this in detail, but again, there will be salary differential, no, to be paid by the employer. Okay, but for more information on how salary differential is computed, so I want you to read the Department Advisory number 01 series of 2019 of the Department of Labor and Employment. Okay, The next benefit is the separation pay. So this is given to employees in instances covered by Articles 298 and 299. So an employee's entitlement to separation pay depends on the reason or ground for the termination of his or her services. So with regards to the ground of termination, we will discuss this thoroughly on the next part of, or probably after midterm, wherein we're going to discuss labor relations. So more on this, on the ground of termination, will be discussed during that topic, no? However, for purposes of separation pay, the employee the employee will be paid separation pay if the employee will be terminated due to the ground of it's actually authorized causes now, but again, on the next paragraph, employee who is terminated for just cause may not be entitled to separation pay, but if termination is for authorized causes, separation pay is due. So in other words, there are actually two kinds of grounds, no, in terminating an employee. The first one is due to just cause. Like for example, if the employee commits a grave misconduct. So like for example, if the employee is caught stealing and after due process, the employee is found guilty, so the employee will be terminated for that particular cause, and that belongs to just cause. Now, if that will be the circumstance, then the employee will not be paid separation pay. However, on the other hand, the authorized cause, if the employee is terminated due to authorized causes, of course, the employee will be paid separation pay, no? Now, example of authorized cause is retrenchment, okay? Especially with this pandemic, there are a lot of companies who laid off, no, their employees just to save their business, okay? So if that will be the case, if the employee was terminated because of that particular reason, which is under the authorized causes, then the employee will be able to receive separation pay. And how much will the employee receive? It's 1/2 month pay per year of service. So an employee is entitled to receive a separation pay equivalent to 1/2 month pay for every year of service, a fraction of at least 6 months being considered as one whole year. So in other words, for example, the employee was terminated on the month of July, okay? And then the employee started work, assuming it's January 1. That's his anniversary, no, or the date of employment. Now, if the employee was terminated due to authorized cause on July, then on that particular year, it is now considered as or counted as 1 year, no? So assuming the employee already worked for 10 years and 7 months. Okay, so July it's on 7 month, no? So with that, the total number of years to be counted will now be 11 years. Okay, since again, a fraction of 6 months is already considered as one whole year. But if the employee was terminated, assuming January 1 is the anniversary or the employment date, if the employee was terminated on the month of April, for example, so that's still the 4th month. So the number of years to be considered on that particular situation will just be 10 years since it doesn't reach the 6-month coverage. Okay. Now, these are the different authorized causes, no? And then it is the separation pay will be 1 month pay. However, it would depend whichever is bigger. Okay. So for authorized causes, these are the following. First is retrenchment to prevent losses, or example, if the company wanted to reduce personnel. And then closure or cessation of operation of an establishment not due to serious losses or financial reverses. And then when an employee is suffering from a disease not curable within a period of 6 months and his continued employment is prejudicial to his health or to the health of his co-workers. And lack of service assignment of security guard for a continuous period of 6 months. Okay, so for the first one, of course, again, this is very, I mean, with this pandemic ba, this is very common, no? Wherein the employer retrench some of their employees uh, to to prevent losses. Okay, closure, of course, if the companies declare bankrupt or they close it down because they can no longer operate due to financial losses or serious losses. So the employees are being laid off, or I mean, they are, yeah, the company is really closed, no, closed down. Uh, and the third one is if the employee is suffering from a disease that is not curable within a period of 6 months. Example of this is, for example, if the employee is diabetic and due to the complication of his illness, the employee lost his sight. Okay, so that is actually one of the complications, no? If you have diabetes, so sometimes your sight, I mean your eyesight will be affected, so that will lead to blindness. Okay, so if that would be the case, of course the employee can no longer do his job, no, because he can no longer see. Okay, so if that would be the case, then the employer can terminate the employment of that particular employee for, of course, for health reasons, no, because it would affect the employee's health, or of course with his coworkers, for example. And then another one is lack of service assignment for security guards for a continuous period of 6 months. Now, for example, if you're a security guard and there, because of, for example, for this pandemic, a lot of employers closed down their business because, of course, the government restrictions. No. Now, if you're a guard and then you cannot be assigned, or were you have no assignment for continuous for 6 months period, then the employer can actually terminate you as part of the authorized causes. But again, you will be paid a separation pay of 1 month per year of service. Okay. Now, question: what if the employee is just a probationary employee, and then, like for example, 5 months, and then the employee will be laid off because of the pandemic, for example, and the employer need to lay down those some of their employees. So commonly, the practice is whoever employees who were uh, hired late, or they call it, the term is actually first last in, first out. In other words, for those newly hired employees, they will be terminated first, no? So in that case, if you're the probationary compared to regular employees, then of course, as a probationary, you will be terminated first, no? Now, assuming you are still 5 months in the company, and then you will be terminated because of to prevent losses. Now, how much are you going to receive, since you haven't reached even a 1 year period yet, or 6 months, no? Now, with that, if that's the case, then that particular probationary employee will receive a 1 month pay, because again, 1 month pay or 1 month equivalent times number of years, whichever is higher. So since on that particular case, 1 month pay is higher, then that probationary employee will receive the 1 month pay separation pay. Okay. Then another one, for these following reasons or grounds, the employee will receive 1/2 month pay per year of service. Okay, unlike the first one, it's 1 month pay per year of service. But this causes the employee is only entitled for 1/2 month pay per year of service. So first one is installation by employer of labor-saving devices. Example for this is instead of the employees who's going to do the job, the employer instead bought a machine or equipment, no? And those employees will now be replaced with the machineries because of the technology. Then that employee will be laid off or will be terminated. So if that's the case, the employee will receive 1/2 month pay per year of service as their separation pay. Then another cause is redundancy, as when the position of the employee has been found to be excessive or unnecessary in the operation of the enterprise. Okay, so in other words, if your position, for example, is will be eliminated because it's already redundant or it doesn't anymore, it's already obsolete or it will be abolished, for example. So that's example of redundancy. And then the next one is impossible reinstatement of the employee to his former position or to a substantially equivalent position for reasons not attributable to the fault of the employer. So position no longer exists or no equivalent position in the company to which he can be assigned. Now, example for this is if, for example, if the employee was initially dismissed, no, due to just causes. Okay. So, for example, that particular employee committed a violation of the company rules, and then the decision is to terminate the employee due to just cause. So if that's the case, and then this employee filed a case against the employer to the NLRC or the National Labor Relations Commission, and then the decision of the agency is to, the dismissal is illegal. Therefore, a reinstatement is being issued, and of course, those monetary benefits, payments, no? Now, if that employee will be reinstated, and of course, normally the cases will run for a longer period of time, no? Assuming the decision was made after 2 years from the filing of that particular case. So it's already 2 years. Now, since again, the employee will be reinstated or will be, the employee will be reporting back to work because of that decision. Now, for example, if the employee is a machine operator, okay, and then when that employee was reinstated, the machine is no longer there, no? There were already major changes, and then that machine operator job is no longer existing. And of course, whatever the effort of the employer to look for a matching job, and but still there's no more available. So again, the reinstatement is already impossible. So if that would be the case, then the employee will be paid the separation pay of 1/2 month pay per year of service. And lastly, lack of service assignment of security guard by reason of age. Okay, for example, if the only available company is a very hazardous industry and would affect probably the age of that particular guard. Example is more than almost a senior citizen, for example. And then the job requires a regular nighttime duty. Okay, so it would be prejudicial to the health of the guard, no, the security guard, if he will be assigned to that particular employer or company. Okay, so with those efforts of the employer of the security guard, there is really no company that would fit, no, on the security guard's circumstance. So again, there is no more services, assignment. The guard would be assigned to, no? Okay, so that's the authorized causes. Now, of course, when you terminate due to authorized causes, there are certain conditions that the employer should need to do, no? And of course, this is the part of the responsibility of HR. So you need to serve a written notice on the employee and DOLE through its regional office having jurisdiction over the place of business at least 1 month before the intended date thereof. Okay, so in other words, you need to notify the employee a month before the effectivity of the termination. And of course, you also need to send a notice, a written notice to the Department of Labor and Employment wherever your office is located, no? So whatever region. So you need to submit to the regional office of DOLE. So it depends on the place of business of the employer. And of course, for the separation pay, it's exempted from income tax if it is brought to because of death, sickness, or other physical disability, retrenchment, redundancy, cessation of business operations. Okay, so in other words, a separation pay is not taxable, no, or exempted. This is your separation pay will be exempted from income tax. And how much the amount of retirement pay? Oh, sorry. Oops. Okay, I'm sorry. I think hold on. This is for the separation. I think I skipped. This is for retirement. Okay, so let's disregard this first. Okay. Okay, so for this slide, this ends the separation pay. No, now let's discuss the next benefit, which is about retirement. Okay, so the retirement actually are given to those employees who already reach okay, let's end the first part of our discussion here, and then let's continue on the second part on the retirement pay. Okay, so